To Katie Cherkasky right now, the former federal prosecutor. Katie, this concerns the non-jury thing. What is the policy for a case like this? Others said that it's the Trump team's fault for skewing the idea of a jury. I don't know what the reality is. Do you know?
Well, the statute allows for a jury trial. The judge made statements yesterday indicating that neither side had requested a jury, which would seem to indicate that the defense had not put in that request because it is a defendant's right to a jury trial. So it's a little unclear why that strategic decision was made. It is a tactical decision. Juries in New York seem to be unfavorable to Trump, so certainly that could have been the thought process there. Obviously, this judge is also unfavorable to Trump, or so it seems. So perhaps that's a regrettable decision now, but it does seem to have been an affirmative decision by the defense based upon what I've seen of the case.
Well, Alina Hanna, the Trump lawyer, says that was not the case. There wasn't a box to check off. It was not an option. Is she misrepresenting that?
Well, there are certain types of cases that are required to be heard by a bench trial. Okay. And my understanding is that this statute does not require that it only be heard by a judge, and that there would have been an option to pursue a jury trial. There could have been some other technicalities in there that led to this outcome. But from what I've seen, it seems to have been a decision that was made, maybe strategically. But at this point, the decision is final. There is no option to select a jury. Moving ahead, the judge will determine the outcome of this case.
Yeah, because it all rests, I guess, with the judge, right, Katie? And one of the things that has come up is, who are you? This is coming from the Trump team, to tell us about real estate, something we've devoted our lives to, or the president would say his entire life to. He knows a thing or two about it. His lawyer is saying that Trump properties are Mona Lisa properties. That's not fraud. That is real estate. In other words, there is a brand and a value attached to real estate that goes beyond what you might see, for example, in Zillow or these popular websites. That's their argument, that these are novices grading the valuations of properties that Donald Trump would know quite well and did not do anything, toward. What do you make of that?
I think that there is a decent argument to be had about the subjective valuation of the properties. And again, we have to remember that the prosecutors decided to not move forward with any sort of fraud charges against Trump on the criminal side for these same filings. So the interpretation of the fraudulent filings under this particular civil statute is very broad, and I do believe it could be open for debate. However, when the judge is the finder of fact and has made a decision regarding those valuations and determined them to be fraudulent, then that is the decision of the trial court. And again, it can be rehashed on appeal, something that the judge mentioned again today. But for all intents and purposes, that has been conclusively determined here. Whether it's fair or not, the appeals court will have to weigh in on that.
Katie, what I don't understand is there's something to Donald Trump's point here. Well, this is a kangaroo court. It's already loaded for bear. The judge has already, slapped down some punishment on properties I have in the state. And if he has his way, they'll be nullified, and I can't do business in the state. And this is all about that and his lifeblood and his earnings in the state of New York. And it would take a Herculean task for the judge to do a 180 and all of a sudden say, oh, there's nothing here. I can't believe we got this so wrong. Does he have a point?
I don't think the judge is going to reverse his own findings. I think that a point of the defense at this point is to preserve the record for appeal, because, again, the appellate court could see things totally differently, and there are significant questions here about the fact that there's been no complaints of any of the parties or the lenders. There's been no actual loss of earnings or profits from these transactions. And certainly I do think
that doesn't matter, Katie. Believe me, you're the lawyer. I'm not. I don't know. But that is not germane here. Proving harm to an injured party that might not be injured at all strikes me as odd, but that is not what's at stake. It just seems kind of wacky.
Well, under the statute, that is not germane to a finding that there were fraudulent filings, regardless of any sort of loss of profits or income. But I think practically speaking, it is quite mitigating when we're talking about enforcement against businesses that are doing fraudulent or corrupt business in the state of New York, which is the purpose of the statute. You have to wonder about whether this was really the intention to go after somebody that was a political opponent, openly somebody that Letitia James had said she wanted to go after. So certainly I think all of those play into the analysis. But under the statute, strictly speaking, you do not need to show harm in order to get an adverse finding against you. It's simply the fact of the matter of filing anything that the judge or the fact finder determines to be fraudulent. Again, very broad definition under that statute, something that the prosecutors did not think that they could prove criminally against Trump in a criminal court.
And a very subjective measure, right?
It's very subjective. And again, the judge's ruling details why he felt that those were fraudulent representations. I think that the argument regarding the brand is very significant because certainly that could increase valuation. But the judge is the finder of fact. His decision at this stage is the final decision.